Welcome. This is Tom McCarthy from McCarthy and Cox, and I'm excited to have this webinar today. Obviously, there's a lot of interest. We have over 60 people on this call today. And so I know you have questions and interest, and we're going to get to the presentation very quickly. Our presenter today is Faye Cox, who, as you can guess, is the spouse of my business partner, Jim Cox. Faye is the managing partner of Schulze, Cox Will, a law firm here in Marysville, Ohio. And Faye has extensive experience in estate planning and guardianships, and many of you are already clients of hers, and you already know the level of expertise she has. For those of you who don't know Faye, I would encourage you to take good notes today, and I'm sure she'll be glad to field your questions and take you as clients if that is something you are looking to do. So without further ado, I'm going to turn this over to Faye so we can get in as much content as we can, and we'll try to get to your questions at the end of her presentation. So Faye, thank you for being here and welcome.
Thank you. Thank you for having me, and thank you for everyone attending, and wish we could see all your beautiful faces and get to participate in person, but given the current times, I'm hoping any day now we can get past this virtual world and be into the real world. With estate planning, you know, the unique thing about the COVID time is that we still have to meet with people in person. I actually have to physically see you signing. So the nice thing is I've still gotten to have a lot of client contact and still get to see people on a regular basis to discuss estate planning. And that being said, you know, people have the same general questions that kind of repeat over and over. So when we deal with estate planning, the concerns are similar, although, you know, every person has a unique situation that has to be addressed uniquely to them. But the number one question I get, or the first starting question, is, do I even need an estate plan? Is there any real reason that I should be going out and spending money on an attorney to assist me, or doing any planning at all? And I guess the answer really relies on if you know exactly what's going to happen to you and your family, and you know what will happen after your death, then maybe there's other ways you can deal with it. But since I don't have that crystal ball, and I haven't found anyone that has, trying to put a plan together that protects you and protects your beneficiaries is kind of the way that we handle it now. You know, if you don't have a plan, if you don't do anything, there's some risk associated with that. And so, you know, if we look at what are the potential risks, you know, one of the things you could say is, you know, who's going to know what exactly you want to have happen if you don't tell them what you want to have happen? So you're really kind of asking them to fumble along and figure it out on their own without any guidance. There's always the risk that, you know, what if you leave someone out? The Ohio law has a direction on who will receive assets, but that doesn't necessarily include your really nice neighbor that lives next to you, or the gal who has been coming and helping you, providing care for you. It doesn't include potentially your stepchild that you consider to be one of your own. So for those reasons, we want to make sure we have planning that includes everyone that we want to include, and excludes those people that we don't want to include. You know, you may have the child or the family member who doesn't show up to the funeral, you know, didn't provide any care, was maybe they stole money from you. Maybe there's, you know, issues or concerns that you go, I don't want them to be included. And again, Ohio law has presumptions that who's going to be in and who's going to be out. And if you want any control or direction in that, you need an estate plan to define that. One of the other issues that we're seeing kind of increase is concerns for cost of probate. bonding costs are going up. People's assets are more and more, higher levels. And as those assets increase, the bond costs increase because they're based upon a percentage of the assets value. So that can get really, really expensive. And then, you may require things like real estate appraisals if you don't have documentation waiving those appraisals. So that can also add to the expense. Another issue is you may not be naming the person that you want to name to be in charge. We all have the person who is great and works with everyone. We know that person, and then we know the person who only creates problems. So again, when you have an estate plan, you get to decide who's in control. And when you fail to have a plan, you're not going to be the one making that decision. Instead, potentially a court will be making that decision. So estate planning, when we describe estate planning, we suggest that includes what happens in case of a disability. So if I'm in a car accident, or I am have Alzheimer's or any other issue that prevents me from being able to make my own decisions. We talk about what happens at death. So how do we get these assets from my name into the name of my beneficiaries, and who are my beneficiaries? And then we also look at, well, what happens if we have creditors, or trying to create an asset protection plan for our assets during our lifetime. When we look at potential risk from failing to have disability documents, the major concern is we aren't going to be the ones making that call. Instead, we're going to have to go to the probate court in the county in which we live in, and our loved ones, or family and friends are going to have to go to the probate court and ask to be appointed to assist us. So that's one of those things that you're going to see me say, well, that's a beautiful building and it's great to visit. We don't want to have to go there because we're forced to go there. We want to only go to look at the architecture. When I have clients who say, well, don't worry about worrying about any disability documents. I've got it taken care of. I've got my son or daughter, they're listed as co-owners on my account. Now, if you have a sole child and that's all you've got, and that's the beneficiary, maybe that doesn't create as much of an issue. But if we have multiple beneficiaries, the problem we have is this creates unfettered authority to use the money. So again, they could take it and steal it. They could use it for their own purposes, and there's no real person there to oversee that use. So and they don't have any fiduciary duty with regard to you to make sure that the money is being used for your benefit. Rather, it's their asset just the same as it is yours. So if I'm the co-owner on an account with my mother and I want to pull out the entire account, I can do so. So that's not necessarily the best idea. The other thing is that, again, it is their money. So while I have clients who will say, they'll do the right thing, they'll split it between my other beneficiaries, or they'll make sure my bills are paid, my funeral bill is paid out of that account. There's no obligation that they do so. So if you want to make sure that it goes to pay your bills and then be distributed evenly, that's just not the right method to ensure that occurs. So what are the disability documents that we suggest for people? The first one being a financial power of attorney or power of attorney for business. What this does is says, if I'm unable to make my own financial decisions, or even right now, if I'm capable, but I just don't want to, or I don't have the time, I can list someone to make those decisions. Now, typically, this is something we'd name a husband and wife as primary agents for each other, so that I can go in and sign a check for Jim and deposit the funds. I can move money around. He can move money around and within our accounts. And so we share that authority. And then we may name a backup, and maybe the backup doesn't have authority until we're deemed incompetent. So maybe it says, I'm going to name this person, but unless Jim is not available and unless I'm not capable, I'm going to handle my own affairs. Again, remember, these are very, very powerful documents. They're also kind of known as the power to steal. The other document that we look at is the healthcare power of attorney. This is the document that says if I'm unable to make my own healthcare decision, I'm going to appoint my agent to make those decisions as well. This kind of you think of as if I'm in the doctor's office, they're of course going to ask me, do you want this shot or do you want this procedure? But if I'm to the point where I'm in the middle of a surgery and I'm unable to answer, or I have, dementia or some other reason that I'm not able to make my own decisions, then this power of attorney would essentially appoint a person to make those decisions on my behalf. And again, it can be very simple decisions, such as should you get your flu shot? And it could be very complex decisions, such as should you have a surgery or not? Now, the healthcare power of attorney can include end of life decisions. So I could say, if I'm in a terminally ill or permanently unconscious condition, I want Jim to decide if I want to remain on life support or not. I also have the ability, though, to execute what's called a living will. So my living will could say, I get to decide what I want to have happen if in the event that I'm in either that permanently unconscious state or that terminal condition. Permanently unconscious, meaning that I'm essentially have no brain activity, and terminal condition, meaning that I'm within days of death and there's no hope for survival. So I could say, if I'm in either of those states, I want you to administer, to take me off any life support, administer no life sustaining treatment. So that's kind of those three documents are kind of really important, and they're important regardless of your age. It doesn't matter, if you're 18 to 88, you're going to need these documents because we don't have those crystal balls and we can't tell you whether you're going to be in an accident or you're going to have a situation where you're not able to make your own decisions. Now, these documents are really important now more than ever because they've created new rules associated with guardianship. So if you don't have these documents, we have to go to the probate court and ask for the appointment of an adult guardian. And then the adult guardian would have to make reports essentially to the probate court as to how you're handling the guardian's decisions. So the new rules require that you have additional education requirements. They require 6 hours of training the initial year you're appointed and 3 hours thereafter. They require reporting requirements, which means that you have to say where your ward is, how your ward's doing, what we think would be most appropriate for our ward. There's a limitation on who can act in that role. So there's some more requirements to make sure that the right person is named. They require background checks. We want to make sure that you don't have a history of elder abuse or anything that would deal with dishonesty. They also require communication requirements. So you have to make sure that you are in touch with your ward on a very frequent basis. And then the service requirements basically mean how we inform the ward and those who are related to the ward as to what's going on, and those have also increased. So it's a much more hefty endeavor in order to take on a guardianship. Aside from disability planning, we also look at what's the planning that we might need to deal with for in the event of our death. And there, we talk about who's in charge, who's going to be making the decisions. We talk about who are our beneficiaries. Are they competent and capable of receiving the assets, or are they of a tender age, or maybe just not very good with money, something like that. We also talk about, how will they get the assets? So how will they get out of my name and into my beneficiary's name? So that's kind of the evaluation we would do. When we look at who's going to be in charge, we're looking at, is that person going to be fair to everyone? Are they responsible? Are they the person, are they your go-to, or are they the last person you would go to? You know, we want to make sure, are they the peacekeeper, or are they the person that's the fly in the ointment, that's always, you know, kind of needling or causing issues? It's really important to pick somebody who is prompt, responsible, and trustworthy. Then we look at who are our beneficiaries, and do we have concerns with regard to them receiving assets? You know, do I have an issue with my, maybe my child is married to an awful person, or I think they're likely to get divorced, and that divorcing spouse may try to take the inheritance. Do I have problems with my child? What do I mean when I use the term child? Does that include my stepchildren? Does that include, maybe I never adopted a child, but I have custody of them? These kind of questions can be, need to be addressed, I should say, in estate planning. Who's going to be the guardian over a minor child? Or if I have an adult child who is incompetent, who's going to take care of them? So those are kind of major questions we need to ask. What if my beneficiary is just bad with money? Who's going to take care of them, or make sure that they don't squander the inheritance? Do they have drug, alcohol, or gambling issues? You know, I don't want my assets to be taken up completely by a drug habit. I also look at, you know, do my beneficiaries have risky jobs? You know, are they doctors, and a malpractice case could wipe them out? Are they, you know, doing something that I'm worried that the inheritance would not go for their benefit, but would go to pay off their creditors? And so we also look at, you know, do we have a second marriage spouses? So, you know, this is a common issue. Okay, if I want to leave everything to my spouse, and I want maybe all my assets at my spouse's death, we both have children, so we want it split equally between our children. And that's great to have that decision today, but will that decision last? When I die, you know, if I had children outside of our marriage, would Jim take care of those children, or would he exclude them? And I will say I've seen this happen quite a few times, where when we meet with the husband and wife, they all agree that, you know, the assets should be split equally between all the children, regardless of which marriage they came from. And then after the death, whether that child, you know, wasn't kind during the funeral or something happened, they're changing their estate plan, and they have the ability to do that if you just leave it outright to a spouse. Now, of course, there's considerations and ways we can plan around that. We also look at, you know, is there pets that we want to take care of? Sometimes people have animals that live a really long time, you know, horses. Some birds can live like 70 years. So we need to take into account the planning for those pets potentially. We also want to look at, do the beneficiaries, are they receiving any governmental assistance? Are they on Medicaid? Are they on Social Security disability? Do they need additional protections that if I give these assets to them, will they lose their benefits, or will those funds have to be used for their care in lieu of the benefits? You know, most people don't want that to happen. And then we also say, you know, do they understand the assets they're getting? You know, are you leaving a major farm operation to a non-farmer? Are you leaving a business operation to somebody who doesn't care about that business or have any interest in pursuing the family business beyond their generation? So making sure we're looking at who's getting the asset, and are they going to keep on the traditions and positions that you would want to have happen, as opposed to what they would want. Another consideration we look at is how are my beneficiaries going to receive this asset? And essentially there's three ways that this can happen. One is through the probate court, essentially either through your will or the state of Ohio will direct how those beneficiaries will receive the assets. We've kind of talked about the idea that a probate court requires hoops that you have to jump through. You can't get to point C until you get past A and B. And so that's something that we look at is how they're going to get that asset. Is it through a beneficiary designation? Have you identified who your beneficiary will be through an account statement identifying the beneficiary? Or is it left in trust and the asset will get to the beneficiaries through a trust administration? Now, I talk bad about probate quite a bit, but there are positives and there are reasons and times when the probate court is the appropriate directive to go through. One of the things is that the probate court can provide oversight, to the for the beneficiary. So they can look at what is the fiduciary doing? Are they doing the right thing? Are they paying the bills? Are they collecting all the assets? And so you do have oversight by the probate court. And if you have a fiduciary who would otherwise maybe be a little squirrely, this makes them put everything on the table. The courts can act as the kind of the hard decision makers in guardianships. More than one time, I've told a client who is kind of struggling with something, maybe the ward wants to do something, but they don't want them to do it. And we say, let's present it to the court, make them make the call. That way they're the bad guy and you're not. So that's something that a court can be good for. In smaller estates, the cost of administration is not that much. The less assets that pass through the estate, the less cost it is to probate. So it may make sense to say it's not worth the hassle to go through putting beneficiary designations on or dealing with these assets. It's just easier just to have them flow through the probate. The probate will also make sure that you have that fair distribution. They're going to say, is everybody agreeing to how this distribution applies? And is it going the way that the will directs or the way that Ohio law would require distributions to occur? You can guarantee that expenses will be paid. The probate court will ensure that anybody who's properly submitted a claim will have their debts paid. So that's one of the things that you can make sure of, that third party, if you left the asset all to a bank account to one of your beneficiaries, that beneficiary could say, nah, I'm not paying that debt, and there's no real recourse. Whereas this, your debts will be paid. And notices are required. So the beneficiaries are going to be alerted as to what's happening as the probate process goes forward. So that's all good. Now, that being said, there are certainly problems with it. And that is the biggest problem, is that it is costly. Around here, it's about 3% of the gross assets that pass through probate. That's a cost. So we want to try to reduce that cost. Most of that, the bulk of it, is with the attorney fees, but there are also court fees. And again, as we talked about, potential bonding fees and potential appraisal fees as well. It's time consuming. And this we kind of talked about as well. The idea that you can't get from point A to point C without going through hoops and without getting approvals. And it's dependent on how quickly do our administrators act. So our fiduciaries, are they signing off on the inventory and account promptly, or are they taking their sweet time? Are the beneficiaries promptly responding to requests, or are they taking their sweet time? So again, it usually takes about 9 months to a year to process a probate estate. So that can, when beneficiaries are looking for money as soon as possible, they may be strapped for cash and they need those funds quicker to get to them quickly. Probate's not going to be the thing that gets it there quickly. The other thing is that it is, I kind of mentioned this, but with the time consuming, it's dependent on the beneficiaries and the next of kin being responsive. So waivers are required. If they don't sign the waiver, they don't take things seriously, everything can be slowed down and increase the cost as well. This is a public process as well. So if I die and you want to know what my assets are, if they go through probate, you can go down to the probate court, open up the probate file and know exactly who my beneficiaries are. You'll know their addresses. You'll know what assets I had. Now, you may not know the account numbers, but you can find out exact amounts that are going through probate. So for that reason, we want to limit those assets that are passing through probate. And also, the creditors cannot be avoided. So if a creditor properly submits a claim, you must pay that debt. It goes through probate, so they are forced to be paid. That being said, if assets are passed outside of probate, for instance, life insurance, those assets aren't subject to creditors' claims. So we much prefer to have that direct beneficiary than we would to have it have to go through probate. Again, remember, the decedent's creditors are the decedent's creditors. They're not the beneficiary's creditors. So beneficiaries don't have an obligation to pay the debts of the creditor, or pay those debts of the decedent, excuse me. So we've got probate, but what other options do we have? What else can we do? Well, we can gift assets. So I could just say, here you go, here's my bank account, or here you go, here's my house. Problem is, what if I want it back? The beneficiary has no obligation to give it back to me. And the other thing is, what if my beneficiary dies first? So I may say I want to leave assets to, let's say my son, but my son dies before I do. And he has one of those horrible spouses that I don't want the assets to go to. Well, that puts me in quite a pickle. So that may not be the best option. Another option would be to do beneficiary designations. Now, here I always say that this is a great option if everybody gets along and plays nice in the sandbox. If they don't, we could have a problem. Use a house for an example. If I put my beneficiaries' names on my home when I die through, say, a transfer and death affidavit, and my beneficiaries don't get along. One wants to sell the house, one doesn't. One moves into the house. There's no obligation that they pay rent because they're co-owners. So this could create quite a mess. I've had clients who the initial beneficiaries, they got along swimmingly. I had a brother and sister that were co-owners. They got along great. Unfortunately, the brother passed away and the sister and her niece and nephew did not get along. And there was quite a protracted situation with regard to how they were going to handle the house and the sale, who's responsible for cleanup, who pays the costs of all that. So that can be a real problem. So you really have to evaluate, do they get along? Do they play nice in the sandbox? Again, who pays those debts? And again, some of them could be the debts that are not necessarily associated with your debts, the decedent's debts, but rather who pays the taxes? Who pays for insurance? Are you going to be able to recollect those funds? So that can be a problem. And beneficiary designations aren't available for all assets. The best example I have for that is a combine. It's a very expensive piece of equipment, but it doesn't have a title. So those kind of things, the beneficiary designations don't quite work. Instead, we might be looking at what's known as a revocable living trust. And that is basically, if you think of it as an agreement with yourself where you give your assets into this trust. The trust kind of acts as a bucket. It holds those assets during your lifetime. You get to use and consume those assets for your benefit and direct what happens to those assets just as though they were held in your individual name. But when you die, you've directed who gets to hold that bucket. And that trustee then would pay your debts and gather your assets, distribute those assets. So that you've got one person in charge. They don't have oversight by the probate court generally, although again, if they were misbehaving, the beneficiary certainly could ask for oversight to be or them be removed and damages associated with that. But for the most part, as long as things go appropriately, there's no oversight. It's a much smoother, quicker, cheaper option. Of course, it's more expensive to start with. So that's one option. Another option might be an irrevocable trust. So if you're thinking, I want to do gifting, but I want to make sure that I've protected those assets during my lifetime, or put some additional rules or regulations associated with it, we might look at an irrevocable trust. Those are probably going to come into more favor in the near future, just based upon some of the tax issues and some of the Medicaid issues that are coming up. So the third area we talk about is asset protection planning. And what is that? Well, it's a plan that basically protects your assets from future creditors, from potential divorce. It could protect you from lawsuits or judgments. So if someone tries to sue you, those assets may not be available. It may be able to protect you from nursing home expenses, or any additional probate expenses. So it's kind of looking at really a big plan that says, okay, what are my potential risks and how do I protect myself from those risks? Now, asset protection planning basically includes, well, what happens in case of a disability, what happens at your death, and other risks that you may have during your lifetime. We always say, could be a car accident. It could be, I have risks that I'd need to go into a nursing facility. So any of those kind of things, it can cover. It also looks at tax concerns and saying, is there a way that I can minimize potential taxes? So we're looking at all of these areas. Now, when we look at long-term care planning specifically, we look at how are we going to pay for that? And potentially that could be through the use of insurance. It could be that you are going to just pay it until you don't have assets anymore. You may look to qualify for governmental assistance. That's done through Medicaid, which is a welfare program that pays for long-term care. Unlike Medicare, which is for anyone over 65 is eligible, Medicaid is not. It is an income and asset-based determination. So you must have limited assets in order to qualify. And then VA benefits. So if you are a veteran, you may also have additional benefits associated to cover that long-term care costs. The biggest thing with long-term care planning is really planning before the need arises. Obviously, you won't get insurance if you are in the need at the moment. You may not also be able to give assets away because there is a 5-year look back that they take from the time that you make the gift. Looking back, they go back 5 years and say, did you make any transfers? And those transfers essentially would be brought back in to determine your qualification. Now, one of the things to look at is some assets are exempt. So we may not want to do planning with those. And that's typically your home is an exempt asset, specifically if you have a spouse who will be living in the home. A vehicle can be exempt if, again, you're living in the home. We also look at creative gifting plans. There might be different ways that we can own assets or transfer assets that could work for long-term care planning, specifically, looking at like businesses, can we structure those transfers? How we title assets, we may do some transfers, we may share assets, we may look at different ways we're going to use funds for our benefit in order to qualify sooner. There are such things as Medicaid trusts, and those essentially are irrevocable trusts that hold the assets where they're not for you. Maybe you get the income from those assets, but the principal of the assets are held until your death and then pass to the beneficiaries you've identified. There are options such as Medicaid annuities and loans. Now, those are kind of coming out of favor a little bit. Those are changing a bit. But one of the things that is kind of nice is they've changed the Medicaid rules as to retirement accounts. Those used to be considered assets, and we used to have to cash those assets out. We're now looking at those being included as income, but not as assets. So we're not necessarily having to cash our retirement accounts out right when we need to use go into a nursing home. So that creates a quite a bit of benefit for our clients. Again, these kind of planning all depends on your specific situation. So, you know, it's asset dependent, it's circumstance dependent, all matters on what you have to determine what might be the best plan for you. The biggest thing I like to take away, though, it's not illegal or wrong to plan. You can plan. It's never considered fraudulent so long as you're not doing it to hinder, delay, or defraud a current creditor. So the fact that you may have a creditor in the future is not at all considered fraudulent. It's only if you're saying, I have a debt right now to this bank or to this person, and I'm trying to avoid that. Again, planning before you have an issue is always okay, but because of that, timing matters. So we need to make sure we're doing plans in advance. Now, in addition to, you know, long-term care planning, another major concern that people have are with taxes. And you may be aware that there have been recent changes with regard to retirement accounts. And so those can have a major impact as well. So in effective January 1, 2020, the Secure Act was set up, and it's called Setting Every Community Up for Retirement Enhancement Act. I always joke that it's setting every community up for a reduced enjoyment, at least your beneficiaries, if we input community for beneficiary. The kind of basics of the act are that the required minimum distribution can start at age 72. You can continue to contribute to your IRA if you're working regardless of your age. So those things were nice for our retirees. You also can take a $5,000 penalty free for childbirth or for adoption expenses. And you can take up to $10,000 from 529 to pay for student loans. So all those things are nice. But when the government giveth, the government also taketh away. And so there is no stretching of an inherited IRA. We used to suggest this was a great planning tool for our next generation to say they can receive this, they'd receive kind of an income stream for their lifetime. But no, that's no longer available. Rather, we must take payments within 10 years. Now, if you inherited your IRA prior to December 31st of 2019, you can still take that over your lifetime. But if not, you've got to cash, it essentially has to be cashed out within 10 years. Now you can decide to take a portion, 1/10 until it's gone. You can take all of it out at the 10th year. You can take half in year 5 and a portion in year 7. I mean, that doesn't matter as long as it is fully cashed out within 10 years. There are some exceptions. Your surviving spouse certainly can still do the spousal rollover. That's not an issue. If you have a disabled beneficiary, they don't have an obligation that they have to pull it out within 10 years. And if you have a minor child of the account owner, not leaving to a grandchild, but if you have a minor child and you are the account holder and you are leaving that, their distribution, that 10-year time frame doesn't start until they reach age 18. So it puts it off a bit. The questions I always get then is, okay, now we're under this new administration. What's the future look like? And again, there's that crystal ball again. I don't have it. When you find it, please let me know. I'm unsure. I don't know what the next plans are. We can look and research what the potential future rules are going to be, but we have no guarantee of what they will be. So we're kind of telling people it's hard for me to tell you how to play the game if I don't know what the rules of the game are. But there's some things that some clients are taking action now just to cover themselves regardless of what the end result ought to be or ends up being. Under the new Biden tax plan, the suggestion is that we're going to have an increase in the capital gains rate. We think there's going to be an elimination of the step up in basis, which would be very, very difficult, very hard for a lot of folks. We also think that the estate and gift tax exemption is going to decrease. Currently, it's $11 million per person. It's a little over that. It's increased through inflation. And then it's going to be reduced. I don't know. I've heard 3.5. I've heard 5. I don't know. That's kind of one of those things we don't know where exactly that's going to end up. We've heard that $1 million in lifetime gifts. Not sure again what that's going to be, and the tax rate could be as high as 65%. With the increase in capital gains rate, the suggestion is that it's going to be whatever your income rate is, and that will be your capital gain rate as well. So, that's a lot of changes, a lot of potential opportunity for planning. We always kind of joke when the tax rules change, that means more work for accountants and attorneys, and probably financial planners as well. So certainly kind of if this is a concern for you, sitting down and kind of potentially making a game plan for what are we going to do, how are we going to address this if they change, is not a bad idea. Again, you can do the planning up until the point that the rules change. So likelihood, if they become effective in 2022, as long as we get our planning in 2021, it should be fine. Additional suggestions that I make to folks is, keep a notebook of your assets, or I know McCarthy and Cox does an excellent job of, having an asset kind of listing that provides what your summary sheet of your assets are. But it is a good idea. If you just have that printed out and keep that with your important papers, making sure your family knows what your assets are. Talk to your proposed executor, guardians, and trustees. Talk to these people about what your hopes and goals are, and plans are. I recently had a friend pass away, and she was such a private person. She had asked me to be the trustee over her trust, and I had agreed to do that, but she hadn't talked to her husband that was going to be the case. And luckily, when her husband called and kind of asked me, will you help me? I need help. And I said, oh, absolutely. Amy already asked me, and of course we'll do that. And it was just kind of interesting to think she hadn't had that conversation with her husband, that when something happens, call Faye. So that's something I definitely encourage people to do, is talk to those trusted people to know, so they know what your wishes are. Talk to your beneficiaries about your plan. You don't want to necessarily shock people. Now, it's a private information. You don't have to share it, and you can change it at any time. But if you know that this is, what's going to happen, let them know that you did the planning. Again, in this situation, I'm not sure her husband even knew that she had a trust established. So, and then review your estate plan about every 5 years. Or if you have a major life event, if you, have a new beneficiary that you want to make sure you're including, if you have a situation where you want to exclude somebody, that you found out new information about them, you want to make sure that you've looked at this and evaluated it. Now, most of the financial institutions will say you need a new power of attorney every 7 years. We kind of suggest let's get ahead of it and just cover it every 5. And it's easy for me to keep track of who's been in the past 5 years. So that's something that I do suggest folks do. All right, and now I think we're at the questions portion.
All right, Faye, we've got a number of questions that have come in. 2 of them are very similar, so I'll try to combine them. They both involve if you have these documents in place, and they specifically mention a living will or a durable power of attorney for healthcare, and the one question was, if they relocate to another state, can they keep the same living will and powers of attorney and will, or should they update them? And the second similar question is, if they're just simply traveling to Florida, will their power of attorney for healthcare and living will be accepted in that state while they're traveling?
And answer kind of goes with both. So your living will, your healthcare power of attorney, and your financial power of attorney are valid in all 50 states. So doesn't matter if you're an Ohio resident and you have executed that document, it is valid. And I have actually had a situation where a client suffered a severe medical issue while on vacation, and the living will became a question, whether it was in effect. We faxed that living will over to the hospital, and the family was very grateful that she had a living will, and then that the state followed the directions of that living will. So yes, it's valid. Yes, it's good. Again, if you have your documents of record with our office, we can always send those out to anyone who needs it. The second question is, okay, if I move to a different state, what happens there? In that situation, I generally suggest you do get those updated for the local for the location that you're in. And the reason that I say that is the forms that are created for a living will and a healthcare power of attorney are state specific. So our medical association, our bar association create these documents together. When they do that, they're slightly different than maybe other states. And I don't know if you kind of recall the Terry Schiavo case in Florida, which was a situation where in Florida, they used the term permanently vegetative state. Well, that's different than our permanently unconscious state. Sounds similar, but they're different. In Ohio, what that means is that there's a lack of brain activity. So we would say they're brain dead, okay? In Florida, that could include, it's minimally conscious. So that could include eye movement. It could include physical twitching, moving, groaning. Not the same situation in Ohio. So the doctors are supposed to be following whatever your directions are within your living will, not necessarily what that form says. So I would say get it so they know what the form is, but then put in within that to say, if let's say you said, I want it to be permanently unconscious state as defined in the Ohio living will document, not what they've identified within Florida, I'd want that spelled out and made very clear so the doctors are aware of this situation, they can follow it. So, and again, you don't want them to go, I don't know what I'm supposed to do because I'm not familiar with this form. So my suggestion was, yes, get a new one, but make sure that it actually follows what your wishes are.
Here's a question. And I think you've covered it pretty well, but Faye, which is simply better, a trust or a will?
So it depends. And I guess the answer is always going to be, is the luxury car better than the regular old generic car? Yeah, it's better. Do you need it? I don't know, maybe not. So we always say that, the trust is going to handle situations and circumstances that a will not. It's going to be a much smoother process, a faster process, but not everybody needs a trust. So I think it's much more dependent on the person than it is than on the document itself.
Yep. Here's a similar or a question from the same person, and this is somewhat of a politically charged question, but I'm going to read it the way it was submitted to us. With the Democratic Party in power, would it be wise to take as much from your IRA without going over your modified adjusted gross income to put it into a Roth, suffer the taxes now as opposed to waiting till later, because we all know their taxes are going up?
Well, I would say, yes, we know taxes are likely to go up. They likely were going to go up anyway, at least on the estate and gift tax side of things, because in 2025 the rules would have been that they would have term limited out essentially. So, but to answer your question, I think that's a great question to ask your financial advisor and your accountant, because those are kind of very, very specific to you to say, what's my financial situation here and what do I predict it's going to be in the future? And again, when you find that crystal ball, let me know. I want to cut it. So that's what I'd say on this.
Here's a question that we received from two different people. I'll try to combine them. It's reading, my husband and I don't have any children. We've named each other as beneficiary on everything. We're concerned though, what happens if we become disabled? Who would pay our bills? And if we're both gone, who would get our stuff?
So Ohio does have kind of again, a safety net for individuals who don't do planning, okay? But it's their rules. It's not the rules that you want, it's their rules. So in the guardianship setting, Union County has what's called a Union County guardianship program, which provides staff guardians for individuals who don't have someone to fill that role. And then they act over guardians over the person. So they make healthcare decisions on your behalf, where you're going to live. They, and the nursing home would essentially, if you were in Union County, the nurse in that situation, the nursing home calls the guardianship program appoints somebody to act in that role. Let's say same situation, but you don't have anybody to act under their financial situation for your finances. What happens is that usually that guardianship program contacts one of the attorneys associated with the program and would ask that they be involved as well. So I act as guardian over individuals' finances. Oftentimes now I have to act in that same role that I talked about, where you have to go to reporting to the court. I have to tell them, here's where all their finances are. If I want to expend funds for them, I have to get court approval. So again, I'm spending time and money to do that. And I'm going to be spending your time and money to do that. So instead of naming somebody that you wish to be named. On the death side of things, if you passed away, again, those assets would pass through probate, and then the probate court would look to, there's a statute, what's called descent and distribution, and it determines who would be the beneficiaries. And if you essentially think of your family tree, they're going to go look, who's your parents? Are they living? They're going to get it. If they're not there, then they're going to go to any siblings you may have. If you don't have any siblings, then they're going to go out to nieces and nephews and whatnot. Now, in the case of two people who don't have an estate plan and who die at essentially instantaneously, and we don't know who died first, you certainly could create a litigation issue where is it going to be one spouse's family receiving those assets or the other spouse's family? There could be an argument who died first. Could make it could be a problem essentially. So always better, that's one of the things that our estate plans include, is kind of a presumption of death, or to say, if you died within 60 days of me dying, then my assets wouldn't pass to Jim, my assets would pass directly to our children, because I don't want to have to go through, maybe he leaves the assets to his mom or something like that, not the way I'd want it to go.
Here's a question that's, I think, sometimes more common than we like to think. Says, our estate planning has hit a wall. We realize we probably should have a trust, but struggle to name a trustee who we can trust. What do you recommend in this situation?
So there's a couple options. One option would be, there are corporate folks who act as trustees. So you could always name, for instance, a bank, Huntington Bank, we work with quite a bit as acting as trustee. But I will tell you, they typically want a very high asset level before they'll step into that role. So minimum of $1 million. And then they also, they're not involved in your family and don't know what you want and wish. So it is kind of acting as a stranger. We've had some small banks act in that role as well. So it depends on the bank if they're willing to do it. Your attorney may be willing to act in that role as well. Oftentimes too, we'll say, maybe I'll act in that role, but I'll ask for somebody to be appointed with me. So I'll say, I'll be backup, or I'll, I don't know that I trust this person. I want them to be involved, but they're going to know everything, but they're not great with finances, or they're just not comfortable with it. Well, maybe acting as a co-trustee might be of assistance. Another option is, and we've got this situation on a couple of clients that I share with McCarthy and Cox, is we'll name McCarthy and Cox as a trust advisor. So we'll say, you name Joe to be the trustee, but McCarthy and Cox is going to be the trust advisor to ensure that they're not cashing out assets that they shouldn't cash out. They're not spending funds inappropriately. And this is kind of that third party who can oversee, make sure they're doing the right thing, and yet be involved. And so kind of, you can have things run by committee. It's kind of, obviously, anytime you do that, the more expenses you're going to get associated with it. But yeah, having a right person in that role is super, super important.
This next question is one I think we see a lot because the rules have changed on these qualified accounts. It says, almost all of my assets are still in my 401k, and I've named my trust as the beneficiary. I have 3 adult heirs and 2 young grandchildren named in the trust to receive the 401k. I'm told the rules on 401ks and IRAs have changed, as you referenced in the Secure Act change. Is it smart to revisit this beneficiary and redo it possibly?
Well, I certainly would say let's look at it and take, evaluate what's needed or not. I will tell you personally, I like naming trusts as beneficiaries to these accounts almost more now than I did before. And one of the reasons is we're able to, use assets within the trust to decide what may be best for the beneficiary, as opposed to, instead of just equally dividing that asset 4 ways, like, maybe you name 2 children and 2 grandchildren, where they're all going to get it a 1/4, 1/4, 1/4. Maybe it's best, my grandchildren probably have a lower income tax bracket. They're going to be receiving the asset over a 10-year period of time when they're still young. I can still have the person, a trustee, in charge of those funds, so they don't have direct access to those funds. But maybe I'd prefer to give a larger sum of trust of retirement assets to them, as opposed to maybe real estate, which I'd rather give to their parents because they're in a higher tax bracket and that wouldn't impact them. So I like flexibility of trust. So I generally am suggesting that. I always use, my family is a perfect example of that. I'm a higher wage and earning individual, and my brother is not. My brother works in construction. So when my parents pass away, if these rules are still in place, I'm going to suggest to my brother, hey, I'll take real estate, you take investment accounts, and we can equalize that. I can look at what is tax impact for him, so that I'm not getting better situation than he is, but I can certainly, play with the numbers and play with the assets to get it so that it's beneficial to both of us.
Hey, I really appreciate it. We have additional questions we're not going to be able to get to because our time has run out. But first, let me just thank you on behalf of all of our clients and the many people who are on this webinar. You did a great job, as we expected you would, and you addressed a lot of these concerns. Once again, thank you, as always, for being our clients. We're here to serve you. And Faye, thank you to you and your firm for working so closely with us on so many people. It really does. I think we all do a better job when we work as a team, and you guys are great teammates. So thank you.
Thank you.
With that, we're concluding our webinar. Thank you for being here today. We look forward to hearing from all of you.